My name is Ken Vercammen, and I'm an attorney in nearby Edison, New Jersey. People in Mercer County, it's so far away, it's so far away. But one of the things we learned from COVID and things being closed down is that we we can do 90% of the stuff without having to go anywhere in our office. So even before COVID, I started emailing questionnaires to people, and so logistically, people could, in the comfort of their own home, instead of wasting their time driving to a lawyer's office and then handwriting up stuff, they could type up their information. And we found that was 1,000% better, because half the time when people were handwriting stuff, I couldn't understand people's handwriting anyway. So it became easier. Let's talk about the important stuff first. So, oftentimes people say, "Hey, Kenny, what do I need to have a will? Like, doesn't everything automatically go to my wife or kids, etc.?" He goes, "Well, it depends upon if it's first marriage, depending upon what's there. But the real thing is that by not having a will, you're in a way you're screwing your family." And last year we had the Mercer County Surrogate join us. And so it goes, the problems that they see in probate is when people try to do it themselves. When people try to do their own electrical work, they burn down their house. When people try to do their own plumbing work, they have sewage in their basement. And people try to do their, quote, legal things, they do it wrong, and they're kind of costing the family more money. But even if if someone says, "I'm not going to do anything," well, the procedure for administration becomes so much more complicated. So it means that, let's say there's 3 kids, so all the kids have to agree upon who's going to be the administrator. The people who aren't going to be administrator have to sign a renunciation and sign in front of a notary, and then filed for a fee with the county surrogate. Then the person who's going to be the administrator has to do more legwork and has to take out a surety bond, which costs $1,000, a couple grand. If everyone doesn't agree, then the administrator has to have an attorney file a complaint, order show cause in the Superior Court. So what's happened? You've said, if you don't have a will and decide not to, you save some money for yourself, but you've kind of messed up your family, because oftentimes it causes fights, aggravation, and sometimes lawsuits amongst the family. So if you they said, if your goal is to cause problems in your family, don't do anything. On the other hand, don't be a putter offer. Everyone says, "Oh, I'm going to get to it, I'm going to get to it, I'm going to get to it," and then people don't get to it. In the next 35, 40 minutes, we're going to talk about how things, how to make things easier for you and kind of save some money and don't waste things. Because, again, when loved ones are grieving, they shouldn't have one more thing that they have to deal with. So think about, okay, who do you want to get your assets? Who you don't want to get your assets? If someone has minor children, of course, there's no one best person to raise your kids, but who would you not want to raise your kids? And again, I always see, as the surrogate says, beware of these online things that say, valid in every state, because people typically do things that are not accurate. So logistically, what most attorneys are doing now is they'll email out a short questionnaire. And believe it or not, New Jersey reduced one of the taxes. They did away with the New Jersey estate tax. And inheritance tax is only if there's no tax at all, if it's going to spouse, children, grandchildren, stepchildren. It's the real tax is when it's going to people who are not, the blood relatives. So, what our interview form, which had been 6 pages long, for most people is only a couple pages long. And for the people that have only adult children, the short form is 1 page long. So basically, who's executor 1, who's executor 2, who gets your stuff, and that's what we're gonna talk about. And by being able to type things up in the comfort of your own home, so it's easier in a way. We've had people come into our office and husband and wife, and then all of a sudden they couldn't agree upon who the executor is going to be. Well, I'm not the mediator. They got to kind of agree upon that ahead of time. So the important thing is get your documents done now. Don't wait until a Friday when someone's about to go into the hospital. We get a call once a week. Oh, I need to get a will for whatever. It goes, well, and we're going away, or they're going to the hospital on Thursday, and I goes, well, there's really not enough time for us to do it right. Now we're talking about emailing it out. Some of the older people goes, I don't have email. I goes, okay, I'm gonna help. We'll help you out that way. Do you have children? Do you have grandchildren? Yes. Okay. I bet your grandchildren or your children have email, right? Yes. And you talk to them, right? We'll go. Here's how it's best to do it. You tell that child or their grandchild, by the way, hey, I want to give you $5,000 to help me out. And if they're not that far away, I'm going to give you $5,000 to come over and help me out in the next 3 weeks. And they can just type up the short form. Now, if that child or grandchild who lives in 2 towns over says, oh, I'm too busy to visit you in the next 3 weeks, well, you really got to think, do you want to leave them anything? Because, boy, if you're saying you're gonna you want to leave them money or help them, and they won't help you out, remember it's your right to leave your assets to whoever you want. So okay, in the will, there's an executor 1, there's an executor number 2. You never want to have joint executors. I'd say they could be twins living together, but it creates twice as much work. That means that 2 people have got to go to surrogate's office. 2 people have to sign every single check. 2 people have to sign the paperwork for sell the house and closings, etc. The idea is make it as simple as possible, and that's part of my theme when I talk to people is let's try to make it easier, not more complicated. And again, that's where you got executors when they agree. Sometimes you get executors that don't agree. So there's only one president of the United States and the vice president. There's only one steering wheel. Don't try to have 2. In your short interview form, hey, who gets your stuff, and if any of those people pass away before you, who gets their share, not that complicated. Now. Remember, though, certain assets do not pass under the will. They pass automatically to whoever the beneficiary is. So examples of those are if a house is owned husband and wife, automatically goes to the surviving spouse. The will can't change that. If you have bank accounts, POD, joint tenants, payable upon death, automatically goes to whoever you have. And then assets passed by contract, IRA, 401k, life insurance, annuity, anything that you have automatically will go to whoever you picked as a beneficiary. So it's very important for you to look at and make sure, 100% sure, 1,000% sure, that's who you want to get your things if it's different from your will. Mr. M called us and he goes, listen, Kenny, I want to have a new will done. I'm taking my grandkids out, my 2 grandsons out. They're in their 20s. I haven't seen them in 2 years. They have nothing to do with me. They didn't even go to grandma's funeral. Okay, we did the new will and give him instructions. Well, he never took the bum grandkids off his 401k. So unfortunately, even though the will said nothing to them, these bum grandkids that didn't even go to their grandma's funeral wake, the next 10 over, they're the ones that get money. So you want to make sure, 1,000% sure. Now, let's talk about specific bequest. Some people want to leave specific amounts of money to a person, a charity, etc. Some people say, listen, I want all my grandkids to get $10,000 or $20,000. Other people will say, I want my jewelry to go to whomever, and that's kind of important because my lady clients know if their son's the executor, he's going to bring the jewelry to cash for gold. He goes, what do you give me for this junk? So like many of the ladies will say, listen, I want my jewelry to go to my daughter, my granddaughter, and maybe it'll stay within the family. What I have been recommending to people when we talk, I goes, well, let me ask you a question. Have you worn any of this jewelry in the past 4 or 5 years? And if they say no, well, why don't you just give it to them now? Let them enjoy it, because if you give them some of the jewelry now, if there's a family event, Easter, Mother's Day, whatever, they might wear it and say, oh, I got this from grandma or whomever. And again, it's your call. So some people have specific requests. Like when I did my first will, I wanted an amount of money to go to University of Scranton cross country team, and then my high school cross country team, because we never had we always had like old crummy sweatsuits and uniforms. So those are specific bequests. We're not now. Some people have collectibles that are worth money. We're not saying they're all the junk in the house, but if someone would appreciate it more than anyone else. There's also a thing that I sometimes call the reverse specific bequest, which is I leave nothing to this person. We don't leave a dollar. We don't put any reason, because it's your right to do with your assets what you want. I'd say the only thing that again you cannot you can specifically put in your will, I leave nothing to my spouse, and if the spouse doesn't have assets, then they can file a complaint in the Superior Court. That's called electing against the will. But there's so in the law there's a thing called the elective share. So if someone's only married a couple years and they each have their own assets coming into the marriage, then if they're not left, then the person's one spouse who dies was not left, then number one, the surviving spouse would have to spend a ton of money filing a complaint in the Superior Court asking for their elective share. Then they look at a list of assets by the dead spouse and the surviving spouse. Okay, so if the dead spouse had $600,000 of what's called probate assets, and the surviving spouse only had $200,000, that's a $400,000 difference. And the surviving spouse can say, I'm entitled under the law to get 1/3 of that difference of $400,000. But if they pass and they have an equal amount, then there's nothing to challenge. Now also, under the elective share, they have to have been living together. Let's see, so if they're separate and apart, other than someone being in a nursing home, then there's no right to an elective share. We just handled the case in Superior Court, Middlesex. The people were undergoing a divorce, and even though the person who died without a will, the judge agreed with us, saying, "Listen, it's a short-term marriage. They were undergoing a divorce. She shouldn't get a windfall. She shouldn't get anything in a 2-year marriage." So, okay. Why can you do this? Well, again, it's your right to do with your money what you want. One of my clients last year says, "Kenny, listen, do I have to treat all my kids equally?" He goes, "No. You can leave everything to the Yellow Dog Society if you want. What's your concern?" She goes, "One of my kids lives on the West Coast. I don't hear much of him." I go, "Well, let me ask you a question. Did he send you a card on Mother's Day, your birthday, or Christmas?" And she says, "No." He goes, "Why would you leave anything to this bum?" "Because he's a bum. What, he hasn't left you. He doesn't call you up. He doesn't have any contact with you." And he goes, "That's why you want to put a clause in the will that says nothing to this person, period." Because what we found is that unless the will says nothing to that person, they're going to be the biggest pain that says, "I want my money, I want my money." And it's sad where people are dumb enough not to have a will, and that person that hasn't been around for 20 years, never helped, never did anything, they're entitled to an equal share as to the person who was the helper. So if you don't already have a will, get one done. Don't be a putter-offer. Don't put stuff off. Don't be like Carl. Who's a Carl? Well, Carl was this retired engineer, and he was old school. He wanted to come to our office and sit down and go over. And it was when there was still a New Jersey estate tax. So I said, okay. So I made some suggestions, and the engineer types go, oh, I like to read more about it. I go, Carl, you don't need to read anything. I went to law school. I passed the bar. I've attended, seminars after seminars. I give the seminars. I wrote a book on this for the bar. You don't need to read anything. I said, when I need a knee surgery, I didn't want to read anything at all about knee surgery. I go, doctor, you've done this before, correct? He goes, yeah. Okay. Well, I know. Carl wanted to read. 2 years later, Carl's daughter calls him. Oh, you know what? Carl died. Do we have his will? No, Carl never did it because he kept on wanting to read. So there's nothing for you to read. Let the attorney do their reading. Now, sometimes in the will, until they're 21 or 25. Just like when someone has minor children, we have testamentary trust. They get some money when they're 25 or 22, 25, and 30, but the executor can expend as much money as needed for college education support. Sometimes, though, we don't leave money to adult children or adult grandchildren, not because we don't care about them, but they have issues. They could be like alcoholics. They could have drug issues. They could have any kind of whatever issues. And the whole idea is you don't want to give an alcoholic more money for booze. So sometimes people set up testamentary trust for people that have issues. Ironically, the people that have special needs kids always set up a special. So you are very interested in setting up special needs trust, but you're when you got the kids that are they just don't work and they're just slackers. You don't want to give them a chunk of money because then you're encouraging them to be slackers. If there's minor children, you set forth if both parents are gone, who would be the guardians and who would be the trustees. Oftentimes it's the same person. The difficult thing, people sometimes put offers when they have minor children. Oh, I can't decide. There's no best person. I goes, okay, let me ask you a question. If you couldn't come home for another week because of some emergency, who would you trust to watch your kids? And sometimes it'd be the parent. My parents. Okay, that's who you're gonna have now. And people go, well, they're getting older. My parents of course they're getting older, but they're the best person right now. The whole idea is look at your old will every 5 years and decide, hey, what changes do I want to make to this now? Now, make sure that if you already have a will, make sure it's a self-proving will. If you don't have a will, then make sure the attorney does your self-proving will. Under the old law, the person signed and two witnesses, but then the executor had to locate one of the two witnesses. Self-proving will, which is better, person signs, two witnesses sign, the person signs again, the two witnesses sign again. Both times it's in front of the attorney and notary. That way the witnesses don't have to be located. And some of the older wills were not self-proving, and I even knew some law offices that intentionally didn't do self-proving wills so they could get the estates. Also, beware of those cheap online forms because they're not self-proving wills, and make sure that your will has a clause that says no bond required. So, logistically, the attorney typically prepares the will. It's signed. We have signings in our office up in Edison by appointment when we have witnesses. Some people goes, I just rather sign at a notary or UPS store on the weekend. Okay, fine. We give people the information on how to do that. So, okay, that's it. And make sure that only the original will can be admitted to probate. A photocopy cannot be admitted to probate. Let's next talk about revocable trusts. My mother-in-law now lives in Monroe now. And she used to call me every other year. Oh, I want to come in and get a trust, and I want to get a trust. And I would say, were you watching Susie Orman on TV? And she smiled, goes, oh, yes. I go, Susie Orman is exactly right. If you live in New York, California, Florida, where the probate process costs 15 grand at a minimum and takes 2-3 years. But New Jersey probate is basically easy. So when people say, what aside from Susie Orman or your friend who lives in another state having a trust, why do you think you need to spend $3,000, $4,000, $5,000 having the trust prepared and then having new deeds done for your property and having your property owned by the trust? Why do you think you need that? To avoid probate? Probate in New Jersey costs about $160. That's not a reason why. Probate in New Jersey is easy and inexpensive. A trust usually costs you about $3 grand a piece. Number two, a revocable trust does not protect assets from nursing home. I'd say three, some of the trust salesman goes, your will is a public record, but a trust is private. He goes, yeah, but why do you need to, if you're leaving your assets to your kids, the will doesn't set forth what assets you have, just who gets your stuff. Also, it requires that, again, with real estate, that there be deed, affidavit, title, all these other things. So, again, there's no need to avoid probate in New Jersey for the most part. Some people, though, want to, transfer their assets in the event they have to go into a nursing home, and then it's a 5-year look back. So that's called an irrevocable trust. And some of the attorneys that prepare these are, experts in the field because it has to comply with federal Medicaid law. They charge 10, 15 grand. Well, a month in nursing home costs 10, 15 grand. So in a way, if you want to almost protecting your assets, do that. And it's better though to spend the money, all this money, by setting up an irrevocable trust if you're concerned about Medicaid, than just giving away your assets. Because once you make the gift, once you give it away, then you've given it away, and you can't get it back. So an example is Mr. M didn't want to spend the money on attorneys or trust. He goes, I'm just going to give half my assets to my son, half to my daughter. I'm doing a quick claim deed, half my house to my son, half to my daughter. Okay, I just got to keep my fingers crossed. 5 years go by, I don't go into nursing home. Well, unfortunately for Mr. M, his son dies. So who now owns 50% of everything he ever owned? His daughter-in-law, basically his ex-daughter-in-law. So, that's who owns his stuff. So, the Medicaid stuff is fairly complicated, but it's things that you should do. Having a will done might cost for one individual $500, $600, but it's an investment, because not having the will, I've told you, is going to cost you thousands of dollars more. So in a way, you save money out of your own pocket, but you're sticking your kids with the mess down the road. And by the way, many people who work for corporations have free wills as part of their benefits. They have what's called legal plans. So in New Jersey, some of the biggest corporations have either MetLife legal plan, the ARAG legal plan, Legalese legal plan. So speak to people who have corporations. Speak about speak to your human resources. So now we've and by the way, anyone who attends any of our online seminars, if they contact our office, like typically attorneys charge a consult fee. We don't charge a consult fee if someone attends our seminar and contact us. Let me talk briefly about what's a special needs trust. If you have a child with special needs, there are experienced attorneys that, instead of having the money go outright to that child, it will go into what's called a special needs trust for that child. But the attorneys that do that, again, usually charge like maybe 10 grand or so to do it, because it has to comply with all of these federal laws. You got New Jersey state law, but remember, Medicaid is administered through the Board of Social Services Welfare, so it has to comply with that. I mentioned only the original will can be admitted to probate. If you can't find your original will, have a new one done. Let's say the photocopy won't be good enough. Don't be a putter offer, like that guy Carl. So the next document we're going to talk about is the power of attorney. The power of attorney. Now, a will takes care of your assets if you pass away. I'm going to post in there's a thing called the chat button on the side about these some of the companies that have like the legal plan, and I'll come back to some of the questions after Dan Fabrizio talks. All right, now let me talk about the power of attorney. Power of attorney is while you're alive. You're giving the ability to a spouse, a child, someone you trust, to be able to make sure your bills are paid and be able to act on your behalf legally. You're not giving up your rights. You're intelligently taking someone you trust and saying, listen, I'm giving you the ability to help me out financially and do what is necessary. And again, it is important to have a power of attorney, because you can never predict when you're going to become disabled. And so a power of attorney is either effective right away or only upon disability. If it's effective right away, it's effective now and stays effective even if someone becomes disabled. That's called a durable power of attorney. Some people make it effective only upon disability, and then there's a need for a doctor note. That's called the springing power of attorney. My client, Fred the carpenter, goes, Kenny, I don't understand these legal terms. He goes, please explain to me in carpenter terms. Okay. If it's effective right away, your son can steal all your assets right away, who's going to be your agent. If it's effective right away, he needs to get a note from a doctor before he steals your assets. Knowing that, you trust your son. He goes, I trust my son in my life. He goes, make it effective right away, because when it's effective only upon disability, the banks oftentimes give people a hard time. The banks are very difficult to deal with as it is, so you don't want to have one more thing that they have to deal with. Logistically, a lot of banks were giving people a hard time, so New Jersey legislature came up with a law that says, listen, if it makes reference to New Jersey statute, they're required to honor it. I'd say they can't say we're not going to follow it. However, it has to make reference to New Jersey statute, which is Section 2 of PL 1991 C 95 C46:2B-11. And these cheap online forms don't have reference to New Jersey statute, so banks aren't going to honor them. A will is good forever. We usually recommend, though, that people re-sign their power of attorney every 5 years, because a lot of banks give people a hard time, like if it's something that's 15, 16 years old. We revise our documents every other year. We've added a HIPAA authorization, a PULSE authorization, right within the power of attorney itself. I recommended it be effective right away. Now, you want to make for your will. You want to make sure your executor 1, executor 2 can get to your living will. I mean, your will, your last will and testament. So don't put it in a safe deposit box, because they can't get to it when it's needed. Your power of attorney, make sure they can get to it, but it's still a good idea to scan it and then email it to yourself, executor 1, executor 2, to your attorney, and also to your financial advisor and accountant, so that they have it in their records. And the whole idea is get these documents done now. Don't wait. Every single week, we get a call from someone. Oh, I need to get power of attorney over Mom, Dad, or Uncle Joe. Well, you can't get power of attorney over anyone. They have to affirmatively sign the papers and give it to you. So we ask the question, okay, can this person call the attorney over the phone and say, this is what I want? And if the answer is no, then we can't do it. Also, can the person read and write English? Let's say I only can understand English, and if someone doesn't understand English, I recommend that they go to an attorney who is like fluent in that language, that can talk to them. Again, I usually say I always got to do what's right for the client, not just not what's right for me. The last document I'm going to talk about before I bring in my our financial advisor is the Living Will Advance Directive. So there's so many like advances in modern science that they can keep someone's body alive, well past where anyone ever would be able to open up their eyes and have any kind of enjoyable life. So the idea is the living will is not for you because you're in a hospital bed, you're not conscious. It's for your family so that your family does not have to be put in a situation where the doctor says, okay, should we remove life support? Because I remember when a doctor asked me that question, it wasn't even a family member. I was the person's power of attorney. Okay, should today be the day? And I'm like, geez, doctor, I feel bad. I mean, to say, let's go do it. What the right decision really is for someone who's 92 years old that's not going to open up their eyes again, but you hate to be the person to say, yeah, let's get it done. So that's why you want to have the living will to say, okay, listen, if I'm in a coma, irreversible condition, terminal like illness, like cancer, ALS, like whatever. Okay, fluids and nutritions to be withheld or provided. We took language from the medical society, so that way the doctors are familiar with it. Next section, artificial machines. Respirators, feeding, respirating. So most people would say, hey, listen, if I'm not going to wake up again, this is what I want to have. And we've also, as time, we've added authorization under the federal HIPAA law so doctors can talk to your number one person, your number two. So most people, it's the same person as executor one, executor two. Other clients will say, listen, I want a different family member because they have more knowledge of medicine. And interestingly, the reason why also a living will is important is, sometimes you have one of the kids that has been around to help out. They live out of state and, they're just not very helpful. I would say all of a sudden someone's in a hospital and they barge into the room and goes, okay, I'm in charge now. This is what we're going to do. And the answer is no. Mom or dad did a living will back in 2003 and they put this person in charge and the hospital says, we're lucky we even let you in the room. The living wills and the quick word we use, advanced directive for health care and medical proxy, etc. We also have a clause that deals with organ donation because we try to recommend that people have an organ, sign the organ donor card. And that's kind of interesting. I went to a seminar put on by the NJ Sharing Network, and I said, what's the maximum age to be an organ donor? They said there is no maximum age. I goes, well, what's good on an 85-year-old guy? And they said skin and cornea. It goes, well, I never thought about that. If I was burned in a fire, I'd rather have old guy skin than the stuff that got burned off me. If I couldn't see, I'd rather have the old guy cornea. So documents in New Jersey you want the will, the power of attorney, the living will. Probate in New Jersey is not that complicated if you have a valid will done. And one of the things you're also buying when you have a good attorney do it, you're buying good witnesses and you're buying someone that if there's ever a challenge could be there to say, hey, we prepared it based upon the person's wishes. I've been involved with will contests everyone, periodically someone will call us they want to challenge the will. And it goes, okay, was it something that was shoved under the person's nose in the hospital or was it done by an attorney? They go, it was done by an attorney. He goes, okay, who is the attorney? And someone said, this attorney's name in Metuch. And I goes, listen, I can't stand that guy, but he's a very, very good attorney. And you're going to have a very difficult time convincing the judge that attorney committed malpractice or screwed it up. Interestingly, when people want to call us about, quote, contesting a will, fellow wanted to, he said, oh, dad left me nothing in his will. He goes, okay, the judge is going to ask you a couple questions. How many times did you see your dad in the past 2 years, including Father's Day, since you live in the same state? Guy goes, none, we had a falling out. How many times did you pick up the phone and call your dad? None. I goes, well, sir, I wouldn't handle the case. I'm sure you can find an attorney that would be willing to take your money, but you have nothing. Just because you weren't left what you thought you were entitled to, doesn't mean that you get any money. So don't wait. Get your documents done. If the documents are done right, then the probate process, in Mercer and the other counties is not that complicated. If you just say, yeah, I'm going to get around to it, and stick your family with a mess, then, you don't keep driving a car and try to save money on not putting oil in because you're trying to save money, and that, the surrogates say that's what oftentimes happens. So, my name is Ken Vercammen. I'm an attorney. I work out of Edison, New Jersey. I was the Cranberry prosecutor for many years, but typically, we try to do as much as possible remote so people don't have to drive around.